From the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
We welcome you to the sixth program that we've entitled The People's Law School. With today's program, we shall conclude this 6-week series, and on this last program, we're going to talk about the courts and dispute resolution, or often we describe it as conflict resolution, and there's some exciting things going on with these organizations in cooperation with our judicial system. As I introduce this final program, I very much want to thank those organizations that have made this possible, not only this TV series, but also a 9-week course at North Idaho College. I first of all would like to express our appreciation to the Conflict Resolution Center of the Inland Northwest Incorporated that is located in Coeur d'Alene, Idaho. We also wish to thank the Community Education Department of this institution, that is North Idaho College, and we also want to thank the First District Bar Association along with the Kootenai County Bar Group. I should add that the Coeur d'Alene Press and the Spokesman Review have also been co-sponsors of the course, and on this program we're grateful for their support. It has been most helpful. I welcome to the program today 3 guests to deal with this final topic. First of all is an attorney, Ken Howard, who is very prominent in the judicial system in Idaho and has served in a number of capacities with the Idaho Bar Association, including the president at one time. Ken, we've had you on the program before, and we welcome you back. It's always a very much an enjoyment to have you here.
Thank you. It's always fun being here, Tony.
And next to him is Heidi Fisher, who's also an attorney in the state of Idaho, and in addition to being an attorney, she is really one of the founders of the Conflict Resolution Center and has done very prominent work along with Sue Flamm and others. Heidi, we thank you for that, and it's been most instrumental to our people and to the court system.
Glad to be here.
And third, we're also very happy to have Judge Barry Watson from the 1st Judicial District in the state of Idaho, and he too, in the capacity as judge and all, has been very supportive and aware of what we're talking about today called dispute resolution. Judge, thank you for being with us.
Thank you. It's my pleasure.
And as always, I'm very pleased to have regular panelist Janelle Burke, who's an attorney in Idaho and a law clerk to a judge in the 1st Judicial District. And we shall ask Janelle to commence today's questioning.
Heidi, I would like to start with you and ask a question about alternative dispute resolution. What are the various forms of alternative dispute resolution? What are we talking about? Can you define that for our viewers?
Well, Janelle, alternative dispute resolution is a field that's really growing, and there's a lot of innovation going on in the area. I can think of probably at least 10 different alternative dispute resolution mechanisms, but I think the 3 that are most prominent and the ones that people probably have the most name recognition for would be negotiation, which is really a form of alternative dispute resolution that's gone on as long as there's been courts and lawyers, and then also mediation and arbitration. And would you like me to distinguish
Yes.
between those?
Could you tell us what mediation is and what arbitration is?
Okay. The most important distinction, I think, between arbitration and mediation is the role of the neutral in these 2 processes. In arbitration, the neutral has decision-making authority and power, much like a judge. The difference between arbitration and litigation is that often the process can be streamlined, speeded up. The parties can agree upon rules of process and admission of evidence and that type of thing that may be more relaxed than the litigation process. But ultimately, the parties do not have control over the ultimate outcome. They hand that over to a neutral who makes a decision regarding their dispute for them. Whereas in mediation, the parties always retain control over the ultimate outcome. They have the decision-making authority. And the neutral in mediation is there to assist them, to facilitate their communication so that it's more productive and constructive, to do creative problem solving with them, to try and develop and evaluate various options for resolving the dispute, to obtain and provide information, but really to be an intermediary who assists the parties in arriving at a resolution which is ultimately their own, rather than being imposed upon them by a third party.
Judge Watson, can you tell us something about why not just go to court? What's happening in the courts now? Why are people turning to alternative dispute resolution mechanisms? Why not just go have the judge decide what is going to happen with my case?
Well, what's going on presently is that the number of cases getting into the courts is just skyrocketing, particularly in rapidly growing areas. The courts are getting backed up with the number of cases that are being filed. You also have to remember that we have a large number of criminal cases that are in the system. Those do take priority over civil cases as a general rule. And in many jurisdictions, to get a civil case in to have a trial, whether that be a divorce case or a lawsuit involving money damages, something of that sort, it can take 1 year to 2 years just to get a trial date. In the time that it's in the court system, the people that are involved in that, the parties, are going through great expense with lawyers' fees or even emotional expense in just being involved in the litigation. And the mediation or alternative dispute resolution process is a way of taking that out of the court process and allowing the parties to get a resolution much sooner than they could get it in court.
In addition to getting a resolution sooner, they have some control over what the determination is going to be, too. Isn't that true? And is there more satisfaction, do you think, when it's decided by the
I think
parties?
that is correct, particularly when mediation is the process that is used, because it is, as Heidi mentioned, the parties that are working with an independent third person to reach their own agreement. I think in general there is a much higher level of satisfaction when the parties reach their agreement. It's more tailored to suit their individual needs, as opposed to having something imposed by a judge after hearing testimony in a case, maybe for only a day or two, depending on the length of the trial. So I agree that the satisfaction is much higher, and particularly in cases involving children, let's say child custody, visitation, those kinds of issues, they really do lend themselves more to a mediation process where the parties know what they want for themselves and what is best for the child, and can accomplish that in a more agreeable fashion than venting frustrations and anger with each other in a courtroom setting.
Ken, one of the questions that I have for you has to do with selection of an attorney. In our lives today, everything goes very fast, and it seems to me that there's more opportunity, shall we say, for entering into disputes because of the vast number of issues that every one of us faces every day. And we'd like to think that we don't ever going to need an attorney, but there might be that case in which you do need an attorney. How do you decide when do I need an attorney, and secondly, who do I go to?
You know, listening to both Judge Watson and to Heidi gives me part of the answer to your question, I suspect, because it really blends a lot of those two things together. Historically, we've had a lot of dispute resolution mechanisms in our society that have now somewhat disappeared. We had a much less mobile society. We had a firmer family structure, that more extensive family within a fixed geographic area. They stayed generation after generation. We had a more refined church and grange mechanisms, and those were all de facto or in fact dispute resolution methods, especially with regard to family disputes and that sort of thing. With our much more mobile society now, we get into disputes and we don't know where to go because a lot of those mechanisms have gone, and so they've cast those problems into the judicial system, and we're struggling with trying to find ways to replace those traditional methods as well as to keep the constitutional methods of dispute resolution, the trial by jury and that sort of thing. So I guess part of the answer of when do you need a lawyer is it depends on the problem and whether or not you can find some dispute resolution mechanism that you can use where you're not going to involve the legal system. That is certainly the best way to do it, not to involve the courts and not to involve lawyers. It's less expensive, and it keeps the level of hostility down. People reach an agreement because of some consensus, which means that they'll live with the result much better. So if you can keep the system out of it, that's the best way to do it, and if you keep lawyers and the courts out of it, that's the best way. If that's not possible, if you find yourself in a complicated situation where you think you know the answer and you think the other person doesn't realize the answer, you may need to involve third persons. And sometimes that involves maybe a mediator without a lawyer, sometimes a mediator, or sometimes a court system with a lawyer. And the way you would select a lawyer really depends upon the kind of problem that you have.
I want to go back to Heidi, and as a member of the board of directors of the Conflict Resolution Center, Heidi, I've heard you talk about this on a number of occasions. There's so many kinds of cases that in which they either wind up in court or could go through this process. And again, I think we should say that we're talking about civil cases, not criminal. Mm-hmm. Once parties have come through the mediation process, let's say that, for example, and they have, with some difficulty, they've reached an agreement that's somewhat complicated. We're not sure it'll be carried out just from their agreement if it involves money and those kind of things. What is your experience? Is it best to go ahead and say, we'll keep the courts out of it, you have reached agreement with maybe even attorneys present, or should one go to court and get the court to approve it to give it more teeth and enforcement?
Well, I think that depends on the context. I'm going to reiterate something that Ken said, that if you can keep out of the litigation process or the court system altogether, that's the ideal. But I'm always a little concerned that people get the notion that alternative dispute resolution and litigation are mutually exclusive paths. And I think it's important to recognize that those can run a parallel course. And in fact, most of the mediation that I do involves cases that are already in litigation, and the attorneys and their clients have decided that maybe we can take a time out from that litigation process and go over here and try mediation or arbitration or something else as a method of resolving this, short of going in and having a full trial and having a judge make a decision. From my own experience, in any case in which you come to a mediated agreement, whether there's litigation in process or not, it's probably best to reduce that agreement to writing, and if there is litigation, to submit that to the judge, for instance in a divorce or family law case, to have entered as an order for enforcement purposes. But really, a mediated agreement is no different than any other contract that you enter into, and if it's appropriately and completely and fully put on paper and everyone is able to sign on to that, it would be enforceable like any other contract if subsequent court procedures were needed to enforce that agreement.
Now, if it's already in the courts and it's sending out to mediation, then the court would have to have it back and approve it, would it not, if it's already in the court, or could you?
Well, certainly in most family law cases it would have to go back to the court for approval by an order, but often in general civil litigation there may be a settlement that's reached in a personal injury case, and the parties agree and the insurance company is going to pay X amount and the other party agrees to receive it, and all that goes to the court ultimately is a dismissal of the case. So in that context, I suppose the judge rubber stamps that the case can be dismissed, but he may never actually see what the settlement terms were.
Judge Watson, as a member on the bench that has to deal with this, what would be your advice? Do you look at these cases differently, and what you'd recommend about whether the court would give it more enforcement by approving the agreement?
Well, of course, if we're dealing in custody cases involving children, we always look to what the best interests of the child are. If the mediated agreement between the parents of that child seems to be adequately taking care and taking into consideration the needs of the child and looking forward to that child's best interest, I think the court would almost uniformly go along with that. In other cases, commercial litigation, cases involving money only or property, really what the parties agree to is up to them, and if they do in fact reach an agreement that would either be reduced to a judgment that the court would sign or a dismissal, as Heidi mentioned, where the case is basically taken out of the court system, we would, most courts I think would generally go along with that process quite readily.
Ken Howard, there's a number of different subjects and cases that could go into mediation, and from your experience, would you, for our viewers, identify some of the specific types of cases going to mediation, and can one anticipate greater success in some of those than others? In other words, are some more risky to take to mediation than others?
Yeah. Offhand, I can't think of any that might be more risky to take to mediation, because as I view mediation, at least in my practice, and I think the way most lawyers do it, it's part of the process. Actually, almost all cases that get into litigation now at some point in time, visit the mediation process. Sometimes it works, sometimes it doesn't. If it works, that's the end of it. If it doesn't work, then they go on to the litigation portion. So almost all kinds of cases, short of criminal cases, I don't see much of that in mediation. You get into the mediation process. Where it really seems to work is where you can work with the people to try and generate solutions that might not be available otherwise. For instance, might be in a family dispute where there might be a dispute over custody. You can maybe fashion some kind of a remedy that is acceptable to both parties, but if they were to go to the judge may only have certain solutions available to him or her. Personal injury litigation, contract litigation, all of them are subject to mediation also. They're all, mediation is a good resolution to those issues if they can be mediated. Normally, the time at which you do mediation is important. One of the whole purposes of mediation is to try and cut down on the costs, cut down on the expenses and the frustrations and the anxieties that attend any kind of litigation. So the earlier you can do it, the better for all parties, for the cost as well as for the sense of well-being. But at the same time, you have to have enough information so that you go in there and do a meaningful job of mediation. So there's a balance that needs to be struck. We prepare mediations less than we prepare litigation, but it's more than nothing. I think almost all suits, almost all conflicts that reach the formal dispute resolution process that we've been talking about are probably subject to mediation, with the exception of maybe criminal cases. And maybe they can even do something with criminal cases as we get into this.
I have one more question for Heidi Fisher before I go back to Janelle. I was at a dinner in which there were a number of attorneys and psychologists and others that were very involved in this some time ago, and they were telling some rather tragic stories from other states and other parts of this state where in divorces, for example, that things became so tense and so bitter, and one party perceived they lost much more than the other. In the end, the tragedy was that the husband went in and killed his former wife and himself. And what came to my mind as I heard these stories and the incredible responsibilities put on a judge, not knowing how this may unfold, would you address that in relation to mediation? Is that something that might create less conflict and less tension and maybe help prevent down the road a tragedy?
Well, I think that's certainly true in the family law context because people are under tremendous stress. They often feel out of control. I mean, totally out of control. You know, their attorneys are handling things, the whole system is alien to them, and yet these are issues that are very intimate for them. It's their whole life. And so I think if they can be directly involved in the process of formulating what the outcome is going to be, that can relieve some of the pressure. And also if you can, once again, accelerate this whole process so that they can have a resolution in a shorter amount of time than a year, that helps. But I want to give an example of a mediation experience that I had as a mediator that I think shows that this is true across the board in litigation. I mediated a case in 1995 that involved professional malpractice. And the case had been in litigation for almost 11 years, including appeals to the Supreme Court on summary judgment and that sort of thing. And those people, both the professional involved and the injured party, this had really been a big part of their lives for that entire time. So family law, I think, is the crucible that we look at mostly that way, but I think it's true in every kind of litigation.
Janelle Burke.
Heidi, would you walk us through a mediation very briefly? What are some of the things, if someone went into mediation, that they could expect to have happen? How would this process unfold?
Well, that's a little bit difficult to do because it depends, the mediation process can vary very much depending on the type of case that's involved, but I think there's two primary models, and the model for family law mediation is that generally attorneys are not involved. They're not excluded, but they're not involved unless the mediator feels that they would be beneficial to the process. And in a family law mediation involving either property divisions in divorce or custody matters or that sort of thing, usually there are a number of sessions. Those sessions are generally short. I mean, they're not all-day sessions. They might be for a couple of hours or so. And the parties come initially, and the mediator will give them an orientation about the process so they know what to expect and what not to expect. And then generally the mediator develops background on the case from both parties. And once the mediator has a context within which to develop solutions, then the parties start work on a collaborative negotiation. And the mediator generally works with the parties both in the same room, but may on occasion meet with them individually or separately if there's issues that need to be dealt with separately. In other civil litigation, usually the attorneys are directly involved, attend the mediation sessions, and from my experience at least, usually those mediation sessions may go for a half day or a whole day, or from early in the morning until late at night, and somewhat the next day. And most of those mediations are not conducted in a joint session with everyone in the same room. There is some initial work that is done that way, and then generally the parties are separated and the mediator works sort of in shuttle diplomacy back and forth between the various parties and may bring them together somewhat. But you don't necessarily just do one or the other, because also I have found that in real estate disputes, sometimes involving neighborhoods or homeowners associations or that type of thing, the mediation model that's used in family law may be more appropriate to that than other types of litigation. So you really have to kind of custom fit the mediation process to the dispute.
Ken, we talked a little bit earlier about attorneys and selection of attorneys. How would one go about if you needed to have an attorney for a particular issue? Let's say now we need a wills and trusts attorney. How does one go about finding someone, or what are the kinds of ways that you can go about finding a person who is reliable?
There are probably the best most effective and time-proven method is to ask around. Ask friends and relatives, people who may have encountered lawyers in that particular area before. Because having an attorney is really a personal relationship. It's how well can you communicate with them, how well can they explain things to you, how well are you able to get some sense about what your legal position is. And so it really is trying to pick somebody who you feel comfortable with. There has to be a comfort zone, if you will, created. So if you can find somebody that you, is a friend or a relative that has already been through that, they might be able to help you with that kind of a selection through that kind of a recommendation. Absent that, there are some, the Idaho State Bar has a lawyer referral service, and you can call them up and say, I need a lawyer to handle a will or a trust or something like that, and they can give you a list of names of people who focus a lot of their work in that area. The Yellow Pages, quite frankly, provide an itemization of lawyers who practice in specific areas. There is a publication that's available in all public libraries called Martindale Hubbell, and that is a list of lawyers, and in there there are bibliographies about the lawyers, not all lawyers in the area, but those that wish to place their names in Martindale Hubbell, and it explains their background and explains what the areas they specialize in. The Idaho State Bar also, in the last 3 years, has started recognizing specialties through certification process. Now, there is not, the last time I knew, a specific certification for wills and trusts in the state of Idaho, but there are nationally. So you might also look for a certifying agency, somebody who tests and examines, and normally that certification process involves a peer review, other lawyers talking about how well they think the lawyer does, also some kind of a test that's repeated maybe every 3 years or 5 years, and then a recertification. Those are all methods that you can use to look for a lawyer.
And when you go to see your lawyer, then that communication is confidential, is that correct?
Yes. Normally you don't have to actually make that statement with your lawyer. The lawyer, as soon as the relationship is initiated, then the communications are privileged to the extent that those communications stay within the office. Now, if the individual goes out and communicates that to somebody else, it's no longer a privileged communication. But to the extent that the communication is just with the lawyer, it's privileged.
Judge Watson, you probably see, though, in your court a number of people who are representing themselves, and we call those pro se individuals. Can you speak about what is the ability to represent oneself? That is, that the court system allows a person to represent themselves if they so choose.
Well, of course, in small claims cases, attorneys are not permitted to be in the process unless it's in an appeal stage. So in all of these small claims cases, people represent themselves, and some do a better job than others, but that's really what is referred to as the people's court, so to speak. Rules of evidence don't apply. Each side gets to put on their case in a fashion that they feel is appropriate. When you get into other areas, however, divorce, domestic relations, commercial litigation, or matters involving suits over money, the person representing himself or herself will be held to the same standard as a lawyer in the court system. That's what the rules are. You must abide by the rules of evidence. You must abide by the rules of procedure. These can sometimes be very complicated and alien to someone that is not familiar with the process. And unfortunately, people representing themselves, particularly if they're going up against a trained attorney, will really have a difficult time in getting their case through the process and being victorious. So the more complicated the matter is, I would say as a general rule, you would want to get some legal advice and get some representation, particularly if it involves litigation.
Heidi, we have less than 2 minutes left, and I have a question we'll have to deal with very quickly. But oftentimes when mediation is taking place in divorce cases and family law, and the two spouses are really jockeying back and forth, even in mediation, and the children get lost, or the child, tell us how the court can protect the child, or have an advocate for the child.
Well, yeah, that's always an option, and that can come from the court itself if it notes a need, or from the advocate for either one of the parties, the attorney for either one of the parties, to seek to have a guardian ad litem appointed, someone who represents and speaks for the child rather than either parent.
On that you did really well, and on that note, we have to bring the program to conclusion. On behalf of Janelle and our panel, we thank all three of you. And Heidi, would you take back to your board how much we've appreciated this series and how it's informed our viewers. Ladies and gentlemen, with this program, we bring to a conclusion the 6-week series on the People's Law School, and we've covered a number of areas of law, and maybe in the future we'll cover some others. And please be with us next week, and we'll discuss yet another issue. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.